Mr. Brown, have you seen Mr. Robinette?
He is coming in right now, Your Honor.
Your Honor, I was trying to talk from the last week.
Okay. You come right up to the podium, please.
You just remove the glasses first.
On the record in People versus Lance Robinette. This is file number 256862. The record should reflect Mr. Robinette present here in the courtroom today. Second, if counsel put their appearances on.
Anthony, Your Honor, for the record, like all of the people, Claire Brown, on behalf of Mr. Robinette.
Okay, this is the date and time set for a sentencing hearing in this matter. Mr. Robinette, did you have a chance to go through the pre-sentence report?
I did, Your
Talk
Honor.
To Mr. Did you have a chance to talk to your attorney about that?
I did. I'm sorry. I didn't mean to cut you off.
Right. Mr. Brown, I do want to mention, I did get a letter from Brett Robinette. I had a chance to review that prior to the hearing today. In support of Mr. Robinette. Mr. Brown, are there any additions, deletions, or corrections that need to be?
No, Your Honor.
Yes. Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do people have any additions, deletions, or corrections?
We do not.
Any challenges to the scoring?
No, thank you.
Anything on behalf of the people for allocution?
Briefly, and I would acknowledge also received a copy of the letter referred to by the court. These are the defendant's fifth and sixth felonies, and the defendant had previous controlled substance charges that were dismissed as part of a prior plea agreement. He has many prior felony convictions. Some involve larceny, including unarmed robbery. That leaves him with the guidelines of 9 to 23 months up to 7 years. There's a probation recommendation of 2 years with 12 months jail with time held in abeyance for 2 separate controlled substance deliveries. In the opinion of the people, would be little difference from the defendant's sentence on his previous 4th felony for larceny ability. That's number 20 of 22 in October 21, where October of 2021, where he was sentenced to only 6 months in jail. This is a situation again where we have another felony. There's restitution of $300. We think it should be enforced as part of the judge's sentence. And as far as the jail time, we don't believe it should be held in advance as recommended by probation and parole. Otherwise, what's the point in having not having increased penalties for defendants repeating the same behavior over and over again when they refuse to follow the orders of the court, or much less abide themselves to the law? Thank you, Judge.
All right, thank you. Mr. Brown.
Your Honor, Mr. Robinette is 37 years old, very well aware of his criminal history. This is, and he admits he's a drug addict. He struggled with this for a very, very long time. This is not a methamphetamine or anything like that. This was essentially, I think it was Suboxone to somebody that was a CI and was begging him for some certain strips of Suboxone. I believe met him in a clinic actually. And at least in Mr. Robinette's mind, I mean, he knows that, no, you're not supposed to do that. But in his mind, he was trying to help out a friend that has been going through probably the same struggles that he has gone through, so he can't understand the situation. It's still illegal. I think that he needs to, and he understands this. When you are hanging around with a certain type of a crowd, you call them your friends, but they're your friends as long as you're doing drugs with them and hanging out and doing what they're doing. When you try to get out of that, it's sometimes very difficult. He does have children. He's got very steady employment. He's got the support of his family. He's got a home and he's very stable in his residency. He's just trying to work and move on with his life. And he did take responsibility for this. Even when he was approached by the police, he didn't make excuses to do anything. He said, I can't believe it. I can't believe I was that dumb. And he understands what he did here. So I would ask the court to take all those things into consideration. There does come a certain point, I think, especially when you have kids, that you're either going to live this life or you're going to try to get out of this life. He's on Suboxone so he can try to get out of this life, and he made a really bad decision here, and he knows it. And he knows he's got to pay for that. But I would ask the court to take all those things into consideration. He knows he's looking at jail time here. I would ask the court to impose whatever jail time it is going to. He is eligible for a work camp program. I don't want him to lose his job and start all over. It's a vicious cycle. So I would ask the court to consider all that when imposing a sentence in this matter.
All right, thank you, Mr. Robinette. Anything you wanted to say today?
Yes, please. Now, I'm gonna try to get this across without, as best I can. So as the prosecutor said, I understand I do have a very terrible record. Growing up around Metro Detroit, the drugs are so prevalent down there. It's just hard to get, it was an ongoing terrible cycle. As he said, in 2021, that's when my son was born. We made the conscious decision to move away from Metro Detroit because I just got tired of it. We moved away. I got it driving while under the influence on the way up here. That was the last time I had ever used any sort of hard drugs. Since I've been up here, I've been on intensive outpatient program. I was in the Suboxone clinic. I successfully completed. I took myself out of the Suboxone clinic myself, weaned myself off the Suboxone, switched to Sublocade. I was on the Sublocade program for 6 months, and I weaned myself off the Sublocade program because that's how done I am with this life. I'm just tired. I'm over it. It's just I'm trying to do better for my kids. I've built a successful business out of nothing that I just would hate to see go to, I understand that I made a terrible mistake. As Mr. Brown said, I know I never tried to deny it. The delivery of the buprenorphine was done with good intention, if that makes any sense. My kid's mom, she stays with me. She's going through some things mentally. She's been in psych ward twice in the past 6 months. I'm the sole provider for my kids. She don't work. I'm just, Your Honor, if you could find a way in your heart to let me, where we can manage a way where I can keep my job without all this going. If I know it's not your problem, but if I do go to jail, I'm gonna lose my partner, my child. I don't even know where my kids are gonna go. They're at babysitters right now, the 16-year-old babysitter that I don't have anybody up here. I don't have family. I don't. Work camp or drug court or anything. I've been on since I bonded up. I haven't dropped dirty. As far as I know, I haven't dropped dirty for anything through community corrections. I mean, if there's any way I can prove to you that I understand this is my 6th felony, they were all stemming from trying to get money for drug use. I'm not sure which felony he's talking about the drug, because as far as I knew, I didn't have any other drug. I know I had a paraphernalia charge, but I had a prescription for that, so they dismissed it. I'm not exactly sure which was the other drug charge, but it's not typical for me to be a drug dealer. That's not what I am. I've seen so many people die. It was with good intention. I just don't want somebody. I was trying to help her now. That's all I wrote.
Okay, well, I read through the report. I'm familiar with the circumstances that bring you before the court on these charges. I'm familiar with your background and your history from the information contained within that report. And yeah, I mean, your record is bad, and you've been on probation a few times prior to this, and you've had some jail sentences, and frankly, if the circumstances of these charges were worse or any different, I think, a prison sentence would have been justified here. And the guidelines call for a sentence of up to almost 2 years in prison. And I think that's where you're headed if you don't get things right here, because number one, the guidelines won't call for a jail sentence anymore. The next court will be in a position of sentencing in prison regardless. And aside from that, you can only go to jail and be on probation so many times. Whether it's myself or a different judge is going to be at the point where, why are we continuing to do the same thing when you're just continuing to read that? So I really think that in this case, number one, I'm going to follow the recommendation in terms of sentencing you to probation. I'm going to sentence you to the minimum term of jail under the guidelines, which is 9 months. I don't have an objection to your participation in work camp if you qualify for that. Because this was a non-violent offense. So I don't have any objection to you being released to the work camp program and if you qualify for that. But I want to make sure that you're aware in no uncertain terms that if you're back here on any kind of violation of your probation, I have up to 23 months. And at that point, your kids, your wife, your job, your business, what you'll be telling me is none of that was as important as committing violations of your probation. And none of that will be a reason to not have me send you to prison if you are found guilty of violating your probation here. I don't have any qualms about doing it. I want to make sure you understand that if you violate your probation and you're found guilty, you will be going to prison.
Your Honor, you
don't have to say
I'm sorry,
anything.
so I apologize.
The proof will be in whether or not I'm signing a successful discharge in 2 years or whether we're back here headed to Jackson. Okay.
Yes, sir.
So
I promise.
that's going to be up to you. You don't have to tell me. You can show me by complying with your probation. And I really do hope that's the way that things go. But I want you to be clear that this is your last opportunity to avoid going to prison today, right now. So the court is going to follow the recommendation. The court's going to sentence you to 24 months of probation. The court is going to adopt as the conditions of the probation all the terms and conditions listed in this report. The court is going to sentence you to 9 months in the Otsego County Jail. You do have credit for 2 days served. Again, I don't have an objection to your release to the work camp program. The court is going to order $300 in restitution payable to the Otsego County Clerk to be dispersed to Straits Area Narcotics for the buy money that was expended as part of this transaction. Crime victims assessment of $130, court costs of $325, attorney fees of $350, state cost of $136, and a $30 supervision fee per month while you're on probation. You do have the ability to seek an appeal of this sentence, and Mr. Brown can provide Mr. Ravenette with an acknowledgement of those appellate rights.
He has signed that acknowledgement, Your Honor. I'm tendering that to the court.
Again, I'm noting for the jail that I don't have an objection to your participation in work camp, but you will need to go with the officer at this time.
Thank you, Your Honor. No, I understand. Can I give my code to my employee?
Yeah.
Okay, thank you. I appreciate it.
That applies to in this case, they serve concurrent to each other. Good luck to you.
Thank you very much.
Brown, we have Ms. Hammond.
It's not here at the moment, Your Honor. She did send me a message. I believe she sent a message. She gave me a little late. I thought she would be here by now. She had to get a ride. That's all I really.
This is a motion hearing, correct?
Correct.
Okay. We're going to proceed with the motion hearing. I'm going to assume if she wasn't here on time that she didn't wasn't interested enough to get herself here on time to participate, so I'm going to consider that her presence is waived. I did receive the briefs of the parties. We'll go on the record. This is People versus Hammond, 56869. Both counsel are present. Ms. Hammond's not present. We're about 5 minutes past the time for her hearing. And so I did have a chance to review the briefs of the parties. How did you want to proceed today? We're going to present testimony, or are we going to rely on the preliminary exam transcript?
I have no problem relying on a full exam transcript. I mean, I thought there was going to be a trooper here. One is unavailable. We knew that.
Yeah.
My office did have the other one. Again, I don't think this is a factual dispute, quite frankly. As I've indicated in my brief, I think the court makes this decision, quite frankly, as a matter of law.
Okay, all right. Then Mr. Brown, just so that you're aware, I did review the transcript of the preliminary exam hearing, so I'm familiar with the testimony that was provided. Mr. Rolla, do you need a second here?
I don't know.
No, thank you. I just wanted to make sure that the trooper wasn't in the hallway.
Oh, okay, gotcha.
Someone told me he might be there and I forgot I would look. Thank you.
All right.
But I still stand by my position that, again, I understand what the transcript says. I don't think this is a factual dispute. I think this is a legal issue.
Okay.
Thank you, Your Honor. I guess one of the reasons that I did have the trooper subpoenaed and submitted some of the body camera footage is because during the testimony, during the preliminary hearing, he would often mention, I would ask him certain questions. I don't recall, refer to the body cam. That is why I brought the body camera footage. I think it would clearly show some of the points that I was trying to make in the brief itself.
Okay, so you did subpoena the officer?
Yeah, I did, Your Honor. I wasn't sure how the court was going to look at this. I don't really know how to go about this, whether to call him just to show some of the body camera footage that
I mean, it's your motion.
he
so
couldn't recall certain things. So
how did you want to proceed?
actually, I think I would just call him and have him view just a little bit of the footage.
Okay, is that officer present?
I don't see him here, Judge. That's why I went looking in the hallway. That's what I was told. You want to give me a moment, Judge? I'll go look, walk through. Please come on in. He is here, Judge.
Okay. Do you want to call him as a witness at this time?
Yes, please, Your Honor.
All right. Officer, can you come forward to the witness stand, please? Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. Please state your first and last name for the record.
Jacob Kennedy,
And can you spell that for us?
Jacobkennedy.
Mr. Brown.
Trooper Kennedy, do you recall the preliminary examination we had regarding the traffic stop of Kimberly Hammond?
I do, yes, sir.
And do you recall during that testimony, I asked you very specific questions and you often told me to refer to the body camera footage?
I do not recall telling you to refer to the body cam footage.
Okay. Do you recall when I asked you how many prescription bottles were in the bag that you were looking through?
Yes, I do recall that question.
Do you recall what your answer was? Okay. I believe the transcript might say you have to refer to the body cam footage. Would you disagree with that if that's what it actually says?
I don't recall, but I wouldn't disagree. No.
And do you recall what name was on some of those prescription bottles that were pulled out?
I believe it was Kimberly Hammond.
But you don't recall how many?
I do not.
Do you recall what the probable cause for your search of that particular bag was?
At the time of the search, we were doing a parole search to determine the belongings of the parolee that was the passenger of the vehicle.
So you were searching to determine what belonged to him.
Correct.
At any time, do you recall people mentioning to you what belonged to him?
They mentioned that they had some clothes and bags in the back and food. I believe he also said he had phone and cigarettes.
And when you were looking through this bag, you said that you found some Narcan.
Yes,
You recall where that was at in that bag?
I do not recall where the Narcan was located in the bag.
If I play a little video for you of your body cam footage, would that help refresh your memory,
Yes,
Your Honor?
Right, do you have any objections, Mr.?
Judge, I don't have any objection. We can mark the body cam footage and play it. Again, that's.
Well, right now it's being offered to refresh memory, so I'm not gonna have it marked. Go
Very
ahead,
good, Judge.
Mr. Brown.
Again, my position, as I said, is a legal position, not a factual.
Okay,
And again, this is just because I believe during the preliminary exam testimony, he couldn't recall, so I'd like to refresh his memory.
okay.
Judge, it's HDMI 1
Okay.
for,
One more question, if I could.
Sure.
I'm gonna show you to try to refresh your memory, but this was, how much of the car did you search before you got to the bag?
I believe I searched the passenger compartment briefly, or the driver compartment.
And the driver's side compartments?
Yes, sir.
Okay, thank you. Okay, this is gonna start around the, I'll start it at the 25-minute mark. Tell me if you recognize this, first of all, if this is you, and this is an accurate portrayal of the body cam footage as you would wear the body cam. Does that look familiar?
Yes.
Okay. That is the Narcan, correct?
Yes, sir.
And would you agree by watching that, did it refresh your memory of when you saw that?
Yes.
How many items did you pull out before you saw that?
Several items. I believe one of those items was a bottle of butane, and based off my training experience, it's uncommon to have Narcan, butane lighter, and butane fuel in the bag at the same time if you're not using those.
And over here. Do you recall Ms. Hammond ever getting into the bag? Was that Trooper Winter?
I believe after we found the vial that contained methamphetamine, he brought the bag over and asked Miss Hammond, and I believe his name was Clayton, whose bag it was, and that's when she claimed the bag.
Was Trooper Wayner doing this with you, wearing his body camera as well?
Yes, he was.
Sorry, Your Honor, I got to look through my notes. I forgot to bring my time. I'm just going to continue playing this real quick here.
Brown, hold on, please. I didn't know if you wanted everybody
Oh,
to see your
I
notes.
apologize. I'm sorry, Your Honor.
Okay, go ahead.
I'll mute this. I don't think we need to sound for this. Recall what that last item that was just pulled out was?
The last time I believe was a single package of Narcan.
No. One right here. It's like nail polish to me, but I don't know.
Right, that was I believe it was a single package of Narcan.
Okay. What was that?
A butane lighter.
So you found that butane lighter way down in,
But that's when I pulled it out yesterday. I was able to observe other items in the bag as I was searching through.
so you pulled out several items, saw the Narcan, pulled out several more items, then saw butane, right?
Yes, I was pulling out items of what I believe were interest at that time.
What items did you think were of interest?
The Narcan, the butane gas that I saw earlier on, the lighter, the prescription bottles.
Okay, okay. How many prescription bottles have been pulled out so far?
I believe it was 3.
Did you examine the labels?
I believe I looked at the labels, yes.
Would this be number 4?
I believe so.
This be number 5?
That's correct.
Maybe number 6?
Sure.
Can you pause that for a second, Mr. Brown? So, I mean, now I'm not sure we're refreshing memory. I feel like
Okay.
now you're asking him specific questions about the video. So I think if we're gonna admit the video and you want to question him on it, then we need to do
I
that.
would
If
move.
you're gonna refresh his memory, then we need to do that.
Okay, I would move to admit to.
And again, Judge, as our previous indicated, we have no objection to it being marked in the.
Okay, so we'll mark that as defendant's exhibit A,
I just have one more.
and the court will admit it. So I want the record to be clear that the witness is watching the video. This is a body cam video of the search of the vehicle and the questions that Mr. Brown is asking the witness. You're being asked as the witness is viewing his body cam video. Go ahead, Mr. Brown.
And Judge, excuse me, but for clarification, the body cam is this officer's body cam, not
That is correct.
the other officer, not
Okay.
Trooper Wenner's body cam. Thank you. Because there are 2, that's why I want to make sure the record is clear.
Would that be number 7?
Yes, sir.
And you're referring to what?
The pill bottle.
Okay, 7 what?
7 pill bottles that were taken from the bag, correct?
That's correct.
And do you recall that whether or not all of those pill bottles had Ms. Hammond's name on them?
I do not recall examining every pill bottle that I pulled out.
Okay, thank you. And what is that?
That is a black vial that I found in the bag. Upon opening the vial, I located what was believed to be residue of a narcotic.
So the vial was closed at the time, and would you agree you found it near the very bottom of the bag?
That's correct.
Thank you, Your Honor. I don't have any other questions.
Mr. Roll, any questions for this?
Yes, thank you. We did this earlier. You've indicated, and you're under a direct examination, based upon your experience. You have experience in investigating controlled substance matters?
Yes, sir.
What experience?
So my experience was through the Michigan State Police Training Academy. We had a multiple day class where several members from the drug teams came in and did a intro to narcotics training. They also did hands-on training where they recreated circumstances where we had to determine what was considered paraphernalia, what could be indicators of narcotic use. And we did hands-on training searches that included these items.
And that's why you made the statement earlier then regarding the butane being found where?
The butane was located in the bag along with Narcan and a butane torch, which are all indicators of potential narcotic use.
Thank you. Now, what was the original reason for the stopping of the vehicle?
I believe the stop was for defective exhaust, defective equipment. The exhaust was extremely loud and appeared to be defective based off the sound.
And do you know if there was any lane usage violations observed?
I believe there was a improper turn, a right turn off of South Otsego Avenue onto West Main. The driver, unknown at the time, who was identified as Kimberly Hammond, made a turn from the correct lane into the incorrect lane.
And to your understanding, would either of those given you a basis for stopping the vehicle initially?
Yes,
Once you stopped the vehicle, did you determine the occupants of the vehicle?
once we had stopped the vehicle, we were able to determine there were 2 occupants in the vehicle. Yes.
And how were you able to determine that?
So, Mr. Roll, I've read the preliminary
Okay.
exam. We don't need to go over all of
All
it.
right.
Let's just go over things that were asked by Mr. Brown or things that aren't.
Very, very good, Judge. I just didn't want an argument later on that there wasn't the foundation for some of the questions I'm about to ask.
Yeah.
Very good, thank
Let
you,
him
Judge.
object.
I appreciate the court's assistance in that regard. Now, you mentioned that there were bags found in the vehicle.
Yes.
Whose bags were found in the vehicle?
At the time of the search, I was unsure of whose bags were whose at the time because no one was claiming any particular item in the vehicle.
Did that circumstance change while you were in the course of looking into the vehicle?
It did. It continued to not change until we located the possible narcotics, where the bag was then claimed by Ms. Hammond.
Okay, now, you were asked by defense counsel how many prescription bottles there were. You said you didn't remember that number.
I do not remember it.
Of the ones that you looked at, whose names are on, names are on those prescription bottles?
I believe I saw at least 2 bottles that had Ms. Hammond's name on it, and I was more worried about what the item of prescription was.
Okay, so I just want what I believe is probably pertinent to the court in this particular matter. At what point in time did you become convinced that you believed there might be narcotics in it when you first believed that was the case?
When I opened the bag, located the butane bottle of butane gas, the Narcan, and later on the butane torch.
And that was in the bags that you had been told by somebody belonged to the passenger.
At the time, it was unclear who the bag belonged to.
How did you determine the passenger's parolee status?
He was upfront about it to my partner, Trooper Wayner. My partner, Trooper Wayner, was talking with, I cannot remember his name at the time. I believe his name was Clayton. And he was upfront about it, presented his parolee card to my partner, who then asked him to step out of his vehicle and began further questioning.
Are you aware of provisions that the law allows for you searching parolees, their persons and their property?
Yes, I believe it was written in his parolee that he had to submit to a search of his person, belongings, and vehicle that his belongings may be in.
And before you did your search of the vehicle, did you get confirmation from Mr. Clayton that some of the objects in the vehicle were his?
Yes,
And once you started the vehicle, did you find additional information that gave you more probable cause before you found that vial, the black box?
yes.
What additional information did you find or did you observe that caused you to believe further that a crime was being committed in your presence?
The items that I believe that showed me to believe that there were narcotics in the vehicle were the possession of the Narcan, the butane torch in the same bag.
And all of that was before or after you finally located the black box, which contained what you believed to be a vial of a narcotic?
That was before.
Which was before?
The paraphernalia was before the black box was found.
Very good, thank you. I don't have any further questions. Thank you, Judge.
Mr. Brown?
Yes, I have just a couple follow-up questions. You just stated no one claimed anything in the vehicle, correct?
Yes,
Objection, Judge, that wasn't what he stated. He did claim someone claimed items in the vehicle. It's specifically as to the last item.
Can you re-ask the question?
This was a parole search.
correct.
Did the parolee ever list specific items in the vehicle?
Yes, as I stated earlier, he stated that he had cigarettes, food, clothes, and bags in the vehicle.
I don't think you said bags, but is it okay? Could we rely on the transcript?
Sure.
Where was the bag located?
The bag was located in the back driver's side seat.
And you just said you were unclear who the bag belonged to. Is that correct?
That's correct.
Was anything in plain view or did you have to search the bag to find those things?
I had to open the bag to observe that.
Thank you.
Any follow-up to that, Mr.
No,
Roy?
Judge.
Okay, Mr. Brown, your argument?
Pardon?
Your argument?
Thank you, Your Honor. For the record, Ms. Hannon is here. I know she was late.
All right, the record should reflect that the defendant's not present. Go ahead, Mr. Brown. With your argument.
Your Honor, I'm going to close this out if that's fine. And
Judge, if we're going to argue, do you want the trooper to step down?
Oh, I'm
Oh,
sorry.
yeah.
Step down, trooper, and is he released from subpoena? Mr. Brown?
Yes, Your Honor.
Okay, you're free to go, sir.
Thank you.
Thank you, Judge.
Your Honor, I would, first of all, I have not reviewed the case that was attached to the prosecution's reply. It does seem to be an unpublished case. In the third paragraph, it basically admits that my client was not on probation or parole. This was a parolee subject to search of both his person and his personal property. The transcript is extremely clear what was named as his personal property. It's also very clear they searched the entire vehicle before they even got to the bag. Before they got to that bag, as was just testified to, they had no clue who the bag belonged to. It was unclear who the bag belonged to. The only thing they knew at that time was what belonged to Mr. Clayton, because he said what belonged to him. Another issue is the traffic stop. I think that's in paragraph 16. People further submitted could be extended because of the improper use of protective equipment. I believe the officers testified at the preliminary exam. A normal traffic stop takes 5, 10, 15, maybe 20 minutes. This was extended out to an hour. Going through all of this, there were some assumptions made, quotes, I assumed, because he was on parole. And again, the hallmark of this is they could have gotten a warrant. There's absolutely nothing preventing them from getting a warrant, especially when you are dealing with a Fourth Amendment right. That's a fundamental right, and it should be viewed with very strict scrutiny. That's why we have warrants. We don't search everybody's stuff because they are simply driving with someone who may be a parolee. We don't search their entire car. There were prescription bottles, multiple prescription bottles in that bag that were pulled out. At least a few of them were examined, known to belong to my client. That should have given a decent indication that maybe this isn't his bag. We're not clear whose bag it is, which he just testified to, but it contains her prescription bottles and her name. It's behind her while she's driving. It's hers. If you want to search it, let's get a warrant. They did not do that. This whole thing is, and I think they even mentioned this throughout the transcript in so many words, they were searching to find the probable cause to justify the search. I don't think the courts can allow that. I don't think society can allow that. It opens up a huge, huge door. You can't just, even when you're searching a parolee, parolee staying in a home, you don't search the entire home. You search what you think might be there for the parolee. So I would ask the court to suppress this. It was an illegal search. You cannot just search something hoping to find probable cause. The trooper just testified, he had no idea what was in the bag. He had to open it, search it to find out what was in the bag to justify the probable cause to continue the search.
All right, thank you, Mr. Rowe.
Thank you. There's several problems with the defense argument. They want to, here's my conclusion. So now here's how the court should find this. Problem with that argument is officers had probable cause long before they got to that last black vial that turned out to have the controlled substances that were turned out to be in the possession of the defendant. The defense makes an issue that, well, there were some objects in this bag, 2 prescription bottles that had his client's name on it. That's true, but there was also the butane, the lighter, the Narcan that were acknowledged to be belonging to the parolee. Now, although it's true that the case that I attached pursuant to the court rule, because it is an unpublished case, it also is based upon several things, one of which I also attached a copy of, specifically the statute that applies to parolees, MCL 791-236. And in it, as you can indicate, and as found by People versus Powell, and also by People versus Thomas, that's 260 Mishap at 457. When you have a parolee, and the reason I chose that particular case is because it dealt with a parolee in a vehicle with someone who isn't on parole. And contrary to the defense claim, if you have a parolee living in your house, you're not just allowed to search where the parolee might have a bedroom. Yeah, you can do that, but you're allowed to search far more greater than that. In fact, that's an issue you have when you have parolees in your home. In this particular case, the matter is even further increased because we have a motor vehicle. And the court, as defense counsel is well aware, we have a motor vehicle exception that creates exigent circumstances because vehicles can be driven away. In this particular matter, yes, you have a stop for apparently an improper turn and defective equipment. You then, upon confronting the individuals in the vehicle, you have a driver and you have a parolee as the passenger. With the parolee, under the statute and under the law, they can not only search his person, but his property. So that's the area around him. That's where they find the bag and they find property that belongs to him. Now, in addition, they subsequently find property that belongs to the defendant, but by that time, they've already got probable cause to believe of the criminal charges of possession of controlled substances has been or is being committed in their presence. Unless the court's very well aware, that's a very, very low standard. They already have that. You need go no further because at that point in time, they can search the vehicle, they can make arrest for the possession, they can impound the vehicle, they can do a whole bunch of different things that they could have done without having to get a warrant. This is a circumstance where I understand no warrant was obtained, but I also understand, as indicated in my brief, by the time we got to, once that first, if you will, the butane torch and the Narcan was found, once we're at that point in time, that gives additional probable cause for the officers to continue to searching the contents of the vehicle. And as the court's also well aware, when they stop a vehicle, they can not only are limited to just the lunging, though, they can search containers in the vehicle, which also applies in this particular case. For all of those reasons, the search was valid. The motion to suppress should be denied.
Thank you. Mr. Brown, it's your motion. I'll give you the last word.
Just one thing that was mentioned, I think, that the butane and the Narcan was acknowledged to belong to parolee. I do not believe that it's anywhere in the record.
All right. As I said, I did review the written submissions of the parties. I reviewed the preliminary exam transcript of the two officers who were on the scene. I had a chance to review some of the video here today and hear additional testimony by Kennedy. And so looking at all of that together, first of all, the court acknowledges that whether or not to admit evidence or to exclude or suppress evidence is something that's within the discretion of the court, and the court's acting within its discretion in ruling on the motion. To me, the linchpin of this is the officer's ability to search pursuant to statute and Mr. Clayton's parole status. I think the statute is clear, MCL 791.236 sub 19, that officers have the consent to search a parolee and any of his belongings, Mr. Clayton, or any of his belongings pursuant to statute. So I don't think there's any question that the officers had the right to search Mr. Clayton and anything belonging to him, whether or not it was in Ms. Hammond's vehicle at the time. I think this is a really interesting fact pattern. I think it's a really close call. There's not a lot of case law, I think, that's directly on point. The cases cited by parties, I think, sort of go to the issue, but certainly there hasn't been, I don't think, a published case that bears directly on when you have a parolee search where that parolee is in somebody else's vehicle that may contain somebody else's personal belongings, and whether and to what degree the officers can search the contents of that vehicle on the basis that a parolee is a passenger in that vehicle. So I'm really relying, and to me, this is a very fact-driven determination here, because the law is clear. If it's Mr. Clayton's or his things, they can be searched. If they're not, then there needs to be probable cause. So the question to me is whether or not the facts support either one of those alternatives. I think the operative facts to me here are the officer's testimony that, number one, Mr. Clayton and Ms. Hammond gave conflicting versions of whose things were what within the vehicle. It was less than clear based on their statements, in which each of them claimed different items belonged to Mr. Clayton. So to me, that's an operative fact here. Neither of them claimed anything, and in particular, Ms. Hammond never said X, Y, or Z are my things. And then with regard to this particular item, and looking at page 9 of the transcript, Ms. Hammond clearly never took ownership or claimed that that vehicle or that bag was hers. I think if she had said X, Y, and Z in this car are mine, or that bag is mine, then I think clearly that the officers cannot search that based on Mr. Clayton's status as a parolee. They would have to have some type of alternate basis to search things that she claimed were hers, or to get a search warrant for it. So the fact that she didn't claim ownership of any of those things, I think, leaves it an open question in the officer's mind as to whether or not those are Mr. Clayton's items. And I think that in and of itself gives them the ability to look into those items. And again, I think if the opposite happened, if Miss Hammond had said, this is my thing, then I don't think the officers can do it on a parolee status basis. But that's not what happened. So the officers begin looking, they see, or Officer Kennedy sees items which, based on his training and experience, indicate contraband or illicit drug use. And so I think that gives rise to probable cause to continue his search. So I think while it started as a parole search, because Miss Hammond didn't state that that bag was hers or any particular piece of property was hers within that car, then just like in the Meade case that was discussed by Judge Hesselink, and I think Judge Hesselink's ruling at the preliminary exam on this issue was a reasonable and correct ruling, and it's one that I'm placing some weight on as well, although I'm deciding this on my own de novo, but I think the rationale that he used at the preliminary exam is applicable here, where this isn't a house with different rooms, this is like a one room in a house that the parolee is located in. And so I don't think it was improper for them to look into that bag. Once they did look into it, they found items which I think led to probable cause to continue the search. I think it's interesting and a good argument that some of the prescription bottles in that bag had Miss Hammond's name on them, but they were traveling together. Based on Mr. Clayton's statement, at least they were living together, staying together. Miss Hammond's statements contradicted that, but at least based on Mr. Clayton's statement, so it wouldn't be unreasonable to expect that they might have mixed property, or that Miss Hammond's might have some of her belongings in something that belonged to Mr. Clayton. So I don't find that just because there were pill bottles with her name on them in that bag, that leads to a conclusion that that was her bag and everything in it was only hers, especially when she didn't claim ownership of it. So I don't find that to be an argument, interesting, that makes a difference to the court's ultimate ruling in this case. So for all those reasons and within the discretion of the court finds that was a proper search and that evidence should not be suppressed. The court will deny the motion. Mr. Brown, if you can prepare an order that reflects that ruling.
Could I just put the reasons stated on the record?
Yes.
And Judge, as Mr. Brown's one where he must just send an email to me with that on there, I can verify.
Okay, and then as to the status conference, Mr. Brown, how did you want to proceed today?
We'll set it.
Mr. Rolla, how many days of trial?
I'm all with this, Judge. This, we'll have lab personnel for the alleged controlled substance unless it's a stipulation. I don't know if that's what he means. So you're talking about a 1-day trial.
Mr. Brown?
I would agree.
Okay. And Mr. Rolla, can you be ready within 60 to 90 days?
I would do it on the outside of 60, because again, for the same reasons I indicated earlier, with lab personnel, we don't know if they've already been subpoenaed for cases during that time.
Okay, Mr. Brown, if we set this for 90 days out, is that enough time for you to be ready?
That's fine, Your Honor.
And for the record, Your Honor, I understand, and normally it's the position in my office that once a motion is filed, all prior offers are revoked. But this was an interesting, if you will, legal motion based upon the fact pattern. So the plea offer that was made by Ms. Wonderful, I can indicate that was for the record.
All right, so the court will set this for a 1-day jury trial at about 90 days out. The court will set this for a final status conference on the motion day prior to the trial date. That'll be the motion cutoff and plea cutoff. So Ms. Hammond, you'll get notice of 2 dates. One will be for the jury trial, the other will be for the final status conference. I'm gonna suggest you be on time for both of those dates.
I just found out about the court date, yesterday, so I didn't get an email on the court date, so.
I'd like to check, make sure the court has it not
Yeah, what's the address?
Yeah, it looks like we got mail returned to us, so you need to make sure that we have the correct address for you, because if you don't appear because you didn't get noticed, that won't be a reason. It's up to you to make sure we have the correct.
So is that with the clerk?
All right, Mr. Roll, anything further from your standpoint on this case today?
Just as to indicate what the plea offer was in this plea, one was dismissing the other enhancement situation.
Mr. Brown, anything further from your side?
No, Your Honor, thank you.
That's all for today. Thank you.
Thank you.
Are you Miss Gardner? Versus Gardner, file number 205997.
Mr. Rourke wanted me to stay for this. It says probation violation hearing, but I don't know what this is. I think it might be an agreement.
Okay. You can come right up to the podium, please. So let's just make sure that, first of all, you're Anna Gardner, is that correct?
Yes.
This was set for a show cause today. So Ms. Gardner, you're before the court today because it's alleged that you violated your probation by failing to make timely payments on your fines and costs. You understand why you're here before. Before we get too far into this, Mr. DeLeo, did Ms. Davis have any kind of suggestions about how she wants to handle this?
I think like we do normally on these, I mean, obviously the goal is just to get her to pay the fines and costs. My understanding is she's paying $615 and owes, I think it's $505.
Okay,
She's got 6 months left before she hits her 5-year maximum. So I think, we can adjourn it 90 days and see if she can get that balance paid in those 90. If she does, obviously submit a discharge. If not, come back and decide how we want to handle it at that point.
all right. So Ms. Gardner, what can you do in terms of making payments on this over the next 3 months?
I can pay off in the next 3 months.
You can?
Yes.
Okay. All right, so what I'm going to do for purposes of today's hearing is I'm just going to enter not guilty plea on your behalf. You do have the right to have an attorney. If you wanted to have an attorney represent you and you can't afford one, you can request a court-appointed attorney. Did you want to do that at this time, or you would have the opportunity to do that at any time?
Yeah.
While we're going forward? You do? Okay. So, Mr. Brown, if you can conduct a evaluation of Ms. Gardner's situation and talk to Mr. Brown before you leave today, he'll get that set up for you. The court will just set a PR bond in this, so you don't have to post any additional money. And then I'll set this for a hearing in about 90 days. You'll get notice of that hearing. It's important that you stay in touch with Ms. Davis so that you can make sure that you get those payments made. If they're made before that hearing, then we'll take that off. You don't have to come back to court. Okay. Does she need to check in with Ms. Davis following today's hearing?
She doesn't, she's actually on telephone reporting with a different agent, so she just needs to continue to follow that.
Okay.
But as you indicated, if she pays it ahead of time, do contact Ms. Davis so she's aware. Ask for this to be dismissed.
Okay. All right. And then otherwise, if you're not able to, then we'll have to come back for a hearing, and you could face up to, this is technical probation violation, so you could face up to 15 days in jail. So it's your best interest to just get it taken care of. Okay. Do you have any questions at all? All right. Thank you. That's all for today.
John, I think